And it's long overdue and well done.
Chris Hipkins.
Thank you very much, Mr Chairman. Mr Chairman, I'm very happy to take what will be a relatively brief call on this bill. I do want to agree with what my colleague Rick Barker said about the importance of Parliament coming together on matters such as this, and I want to acknowledge the contribution that the Minister has made to this debate. Generally, in the 3 years that I've had the opportunity to sit in this House, I've found committee stage debates are far more useful, constructive and informative where ministers are engaging in the debate as well as opposition members. Sometimes we can spend an awful long time talking amongst ourselves on this side of the House. Actually, when ministers engage with the debate, I think that makes it a lot more useful. I want to, however, just sound a word of caution around the way the Minister framed one of the central issues in this debate, which is around the rights to a jury trial and the right to a speedy trial, and that he framed the issue as if those two things necessarily were in conflict with one another. And that's something that I fundamentally disagree with. I don't believe that the right to be tried without undue delay necessarily should result in a trade-off to the other rights that somebody has when they are being tried. Because if we were going to go down that road too far, in fact we could find that the court system could be made a heck of a lot more efficient, time-wise, if we did away with a whole lot of the other rights that people who find themselves before the court system have at the moment as well. So I think we have to be very, very cautious if we want to frame this debate in that particular way as the Minister did. I listened very carefully to the contribution of my colleague Rick Barker, the first contribution that he made, and it was actually the points that he raised in there that sold me on the extended time frame for a jury trial, because I think, as he pointed out, the length of the sentences for different crimes have changed significantly since the threshold was first established. And it seems to me that it's therefore reasonable that there be some indexation, as Rick Barker suggested it should be, of the penalties to the threshold for a jury trial. I think that was actually a very reasonable point that he made, and I think that that was ultimately the one that convinced me that we were probably doing the right thing when it comes to extending it to 2 years, which is what the supplementary order paper will achieve. I do note in this debate that this is only the second time the Bill of Rights Act has been amended since it was first enacted in 1990. The first time it was amended in 1993 was not long after it was first passed, and that amendment to the Bill of Rights Act extended the protection it offers. This is the first time since that law was passed that Parliament will be voting to reduce the protection afforded by the Bill of Rights Act. And I think it's really important, therefore, that in doing so there is broad consensus amongst the Parliament about that. I think it would be very unwise for a government to do as others have suggested and pass simply by a narrow majority, and I want to acknowledge the fact that the Minister has made an effort to secure a larger than a simple majority for this piece of legislation. I can't envisage any government, any responsible government, whether it be a National-led one or a Labour-led one, endeavouring to do anything other than that. I think it would be absolutely wrong for a government, whether they had a majority or a minority with support from others, scraping together the numbers to get a bare majority to pass an amendment to this legislation. The Bill of Rights Act is something that governments should not tamper with lightly. It is something that there should be broad consensus when those changes are brought forward, and I think it's welcome that this has happened in this case. I wanted to turn to one other amendment which I had some concerns about, which has been addressed in the government supplementary order paper, and that was to do with the case management system and the requirement for the defence to formally identify issues that were going to be in dispute. I think it's a fundamental rule of the court system that it is up to the prosecution to determine or to prove somebody's guilt beyond reasonable doubt. And the suggestion that at the beginning of a trial it should be up to the defence to specify the issues that they were going to be raising in their defence outright at the beginning, and therefore potentially limit the defence's scope, it seems to me to cut across that principle. And one of the things the government's supplementary order paper that's been introduced today ensures that issues in dispute can be identified, Mr Chairman,
Chris Hipkins.
by the defendant only if he or she wishes to do so. So they're not necessarily going to be compelled to do that, and I think that that's a reasonable amendment. I want to... I was going to talk a little bit about the absence of the defendant, but having read that, I'm reasonably comfortable now that the supplementary order paper has dealt with most of the concerns that I had around that. So I want to turn now finally to another issue which I think we need to look at further in a future Parliament, and that is the issue around name suppression. And I'm not going to go into that in too much detail at this point because the concerns that I have are largely wider than the scope of this particular legislation. But it is apparent, in my view, that we are developing a two-tiered justice system where those who have significant money, status and prestige are able to obtain name suppression without too much difficulty, while those at the lower end of our society's status ladder are subject to a different form of justice, and to me that seems fundamentally wrong. There was a case recently, and I'm not going to go into the details of it because there is suppression involved, but it was widely publicised only a few weeks ago to do with a security breach at an airport. Most of the details have subsequently been suppressed. It was widely covered in the media. Anyone following it in the media would know all of the details. For reasons that I cannot fathom at all, the details have now been suppressed, preventing people from talking about it further. It seemed to me totally bizarre. And I think that name suppression is an issue that the next Parliament must deal with, because there are huge anomalies in the number of people receiving name suppression at the moment, and in many cases I don't think they can be justified, and I think that's something that definitely needs to be very closely looked at. So I'm going to conclude my comments at that, Mr Chairman. I'm not a lawyer, so I take a layperson's view of this particular piece of legislation. I've followed the debate quite closely. I am satisfied that the major concerns that I would have otherwise had around the fundamental human rights have been addressed. There is a balance to be struck between ensuring individual rights and making sure that people have access to the justice system in a reasonably speedy way. Definitely, I think there is a problem with with New Zealanders' rights to a speedy trial being compromised at the moment, and I think it's important that that be dealt with, and this legislation definitely seems to do that. Mr Chairman.
Honourable